So, ladies and gentlemen, thank you so much for your time and for joining us to discuss this very, very important topic, wills and trusts. And before we jump in, as usual, it is part of our DNA at WestQ to always include the Holy Trinity in everything that we do. So let's say now the Synod prayer. We stand before you, Holy Spirit, as we gather in your name, with you alone to guide us. Make yourself at home in our hearts. Teach us the way we must go and how we are to pursue it. We are weak and sinful. Do not let us promote disorder. Do not let ignorance lead us down the wrong path, nor partiality influence our actions. Let us find in you our unity so that we may journey together to eternal life and not stray from the way of truth and what is right. All this we ask of you, who are at work in every place and time, in the communion of the Father and the Son, forever and ever. Amen. This evening, I have the pleasure in studio with me two beautiful young ladies. And to my right, I have Ms. Anne-Marie Francis Giles, and she is a director of the Board of Directors of Western United Credit Union and an attorney at law. To my left, I have Ms. Joyce Lynch, the second substitute to the Board of Directors, and she is also an attorney at law. Ladies, welcome.
Thank you, Mark. Thank you.
Thank you as well. Now, it is said that clear communication is attractive. Some people may dare to say that it's even sexy. Yes? So this evening we are here to communicate very clearly and to educate our membership and the general public about wills and trust. And please know that it is general information that we are given this evening. To some persons, you may go and you may sit with your lawyer, and your lawyer would advise you specifically to your situation at that time. That's correct, Anne-Marie?
Yes. Yeah, that's true.
Yes. So the information that is being given to you is very general. So we will jump right into it. And I think I will throw this one out to Anne-Marie first. So Anne-Marie, wills and trust. What is a will and why it is important that an individual must have or make a will?
Well, Mark, a will is really an expression, a documentary expression of individual's wishes or desires after he dies. What he wants to happen with his property, his assets, who he wants to benefit from his assets and his property or estate when he dies. So that essentially is what a will is. It's important because it gives the individual or the testator control, really. That's what I say. Control of his assets, control of his estate in terms of who he wants to benefit and what he wants to give to that person or persons. So it's essentially, it gives them control. When you die, you don't have control of what happens after you're dead.
Afterwards, yes.
When you're dead, you're done. So essentially, they say, where there's a will, there's a fight over inheritance. But,
Yes.
but when you die, persons may, in Trinidad, come out the woodwork.
Yes, yes.
And want to exercise some sort of claim on your estate. So if you want to have control, I think the will is the way to go while you're alive.
Yes, to put things in place.
Put things in place.
So at least you know that when you depart this world, you will be comforted in knowing, well,
Yeah.
that I have left.
On the other side.
Yes, I have left things in place so that my wife and my children or whomever I am living with
will be taken
taken
care
care
of,
of,
right.
and that is okay. So, sticking with Anne-Marie, what is the construction of a will? So we understand and we got an appreciation of what a will is and the importance of a will. So in terms of constructing a will, what is the process or what is within the construction of a will?
I think when you say construction, in law we really look at it in terms of the words used and the meaning to those words. So when you're doing a will, if you're doing it personally or if you're going to tell an attorney to have it done, we try to be specific, simple. You don't want to use words that are ambiguous in meaning.
Yes.
So that would cause, problems if the courts have to interpret after. So we try to be as simple as possible, and use words that can be clearly understood, that problems would not arise after. And it's important to know too when you're doing a will. If you've ever seen a will, it always states, this is my last will and testament and so forth. So essentially you want to, because you may change your mind subsequently.
Yes.
So it's important to date your will, of course. So even though this month you might do a will, this is my last will and testament. And next week, you get vexed with a beneficiary and you and you decide to change your will,
So he or she ain't treating me good
right.
anymore. Yes.
So in that case, dating a will is of course important. So you would need also to have, according to law, you have to have 2 or more witnesses.
Yes.
To attest to one, either your signature being present at the time when you're signing the will, or if you are not signing in their presence, you acknowledge your signature in their presence. So you show them, this is my signature, and they will see it, and at the point in time, the witnesses have to be present together when they are also signing the will. In law, according to the Wills and Probate Act, the signature must be at the foot of the will. Right.
Okay, so you're saying the construction of the will, your will must be dated. The will must state very clearly what...
Well, use simple words,
as much as possible,
yeah.
Because ambiguity, you don't want people have to go to court to interpret what does this mean. Did the testator, is it really his desire to leave it for this person or another person? And the will must state that the person is in their right mind when they are doing the will.
You don't have to state that. That is something that have to be proven if somebody contests it. It's assumed that the testator must have what they call testamentary capacity, and so of course the person should have the ability to make a will, testamentary capacity, in their, as they say, in their right mind, know what they're doing, and know the person, the effect of what they're doing.
All right, so that goes into to what should be included in a will. Some of the things, I guess you would have answered some of them. In terms of,
included meaning your assets?
Your assets. You can list your assets.
One of the things we always advise when you're doing a will to be specific as possible. You can't say, okay, I give my car and you have multiple cars.
Yes.
Be specific. I give my car vehicle registration number to ABC. So don't be vague, be as specific as possible when you're making certain requests and so forth.
Yeah. So you must be very clear in your will exactly what you are willing, what you are gifting
Yeah.
to any individual. You wanted to say something, Ms. Lynch?
There's also in construction of a will some rules for making the will. Example, you must write with a pen, not a pencil. Little rules that you have to conform with
When you're writing the will.
and where exactly the testator signs and the witnesses signs, how
Yeah.
to do these things.
At the end, what you will say at the bottom thereof.
And if I don't follow these rules, what is the will null and void?
It depends on what, what is the nature of the rule that was, not followed. It may not be deemed, the whole will may not be deemed null and void. Parts may not be, deemed null and void. But the court will have to determine on a proper interpretation of the entire will, the will as a whole, if it will stand or not.
Okay. And Ms. Lynch, this question is for you. So, thank you, Anne-Marie. I'm coming back at you. What is an executor or an executrix? And what are their rules in executing the will, if any? Because you always see that a will has an executor or an executrix. So it is important for us to understand why the will has an executor or an executrix and what are their rule and functions in executing a will, if any at all.
An executor of the estate is the person responsible for carrying out the wishes of
The testator?
yes, the testator. And he handles all the other tasks associated with closing out of the deceased affairs, such as funeral expenses, and so it's not only what he has in the will to do, but what is expected to do for the deceased.
For the deceased.
Yes.
Yes, Anne-Marie?
Well, that means paying all his debts and testamentary expenses and so forth, other than complying with the wishes in terms of who benefits and so forth. But sometimes the person, the testator, may not pinpoint or name an executor, but sometimes they can be inferred. They might say, I appoint A to be an executor, but it can be inferred based on the reading of the will that he might give instructions. Or I appoint or Miss A, B, and C, or Mr. So-and-so is to do this for me, or is to pay my funeral expenses, or to ensure that so-and-so benefit from. So it might be implied. It may not be expressed specifically as appointing so-and-so. I appoint A as executor and trustee. It may not specifically state so, but the court may infer. You can infer that this person, by the reading of the will, is to perform the duties of executor.
Okay. So that may have answered my next question. And must a will have an executor or an executrix?
Executrix, female, male.
Female, male.
Right.
That may not be necessary.
It's advisable, but I said if the person doesn't, and if the will is made by an individual without consulting an attorney, you may find that it doesn't always conform in terms of naming a particular individual as executor or executrix. What I have experienced over my short stint is that sometimes people put persons as or name them as executor or executrix,
Yes.
and they do not inform
The person.
the person.
So the person is not aware at
Yes,
all.
yes. I had
Yeah.
a case where the person did not know that they were named in the testator's will.
Mm-hmm.
So I always advise people, seek the consent, because sometimes people don't want the burden,
Yes.
the responsibility
Yes.
of doing or performing or the role of an executor or executrix. So if you're preparing your will, consult. I'm thinking about, are you willing to perform this function on my behalf?
Mm-hmm.
So it's nice to at least seek, if it's possible, seek the consent of the individual to be named.
As
Yes.
either an executor or an executrix, especially if there may be some bad blood in the family. That is another bone of contention.
Yes, I had a case where two sisters,
Yes.
and one was probably more responsible than one, and there's a tension arose over the course of the year that the mother would have relied more on one sister, probably because of her level of responsibility,
Yes.
and one education too and all that, and she was named as the executor. So she has always thought that she felt that these things were part of the problems of the relationship between her and her sister. So individuals and humans are strange.
Strange beings,
Yes.
and especially so there is tension when mother is alive, and now mama has gone, and there's more tension now because mom decided to leave you as the executor or executrix of the will, and maybe saying what I can and cannot get, or who is responsible for taking care of the turnout, who is responsible for paying this one, and so forth. So it is important that an individual whom the testator may have chosen to be either the executor or the executrix, that person knows in advance.
I advise, because as I said, sometimes
they may not want that burden,
may not
as you
want the
said.
responsibility.
Yeah.
I know sometimes you also have, even though life is not and death is not guaranteed, but death is guaranteed, but you don't know when.
Yes.
Choose when you're choosing someone. Don't choose somebody who is way older than. Although you may have faith and you trust in that individual, the likelihood that the person may die before you, if given the the flow of the normal flow of life.
Yes.
The person may be very old, and the chances are that they could die before you. So you have to consider all these
The
things.
age of who you're leaving as the executor or
And
executrix.
witnesses too. So because sometimes when you want to, or you're going through the application process, you're asking, is the witness alive?
Yes. So all of that plays a very important role in your will. So so far we have understood what is a will, the importance of a will, the importance of an executrix and an executor, and the construction of the will, what must be in the will. It must be very simple. Excuse me while I help out Anne-Marie. Good.
Thanks.
You're most welcome.
There's also
True cooperation spirit, right? Yes.
Yeah, I was saying there's also the fact that some wills may not have what is called a residuary clause to take into account things, benefits that the deceased person would have had. Sometimes he doesn't even know, and these things will come about. So it's important to have a clause in there, in case any new benefits or properties or so would come to the deceased.
Okay,
So
so
that
what is
will be shared.
what is a residuary clause? What does that mean?
It means a clause that would allow benefits to the deceased to to be shared
To
as
be
he-
taken
to-
into
to be
consideration,
shared in his
even though it
will.
is not in the will?
Like the
Yes.
residue, right?
It's like the
Right.
residue, yes. So those things may not be even known to the person who's died. That he has this and he has properties here and he never knew that he had it. He inherited things, he may win a lottery and have money too. So
Okay.
that clause is important to distribute those assets.
So the residuary clause, I'm not a legal mind, but I'm just trying to follow.
No, yeah.
Right, so the residuary clause takes care of any asset
Residue.
that the testator may not be aware that he or she has.
Or would not have been accounted for in the will.
Accounted for in the will.
In terms of a beneficiary,
So therefore the court then would be responsible for distributing those auxiliary.
No,
But if
it's
it,
saying
once
once it is in the will,
You
the
name a person.
executor will.
But I am looking at it from the point where you said that the executor may not have known.
not the executor, the testator.
The testator, sorry.
So it's advisable
the
to
testator may
include.
not have known that he or she had this asset. It may have been gifted to him or her from their mother or father, and they may not have really known. So now that I have passed on, and there's a will, but it was not included in the will. Like, okay, I have a piece of land, but it is not, I didn't know. I see you raise your brows here, Anthony, so which means there's a little bacchanal there. I may not have known that this property was left to me, but I have a will. It is in the will, I have my executor, my executrix, and things are shared equally among my family, amongst my family. However, I didn't know that a property was left for me. So it surfaced. How is that property going to be fairly distributed among my loved ones?
If the clause exists, if a clause exists, the executor of the will would know how to treat it. So he would put in a clause and says, in the event that I may have other properties that I didn't know of, then these properties should be shared equally among my children or some, So he would know what to do about it. If the clause does not exist, the courts will have to,
they would have to take responsibility to ensure that things are fairly distributed. Okay. So
simple things could happen too. This deceased person might have had joint ownership of property or businesses, which he didn't even think of
putting in the will, so that could be taken care of there as well.
Yes.
Okay. So so must a will, I made my will, must a will be registered for it to be enforced or honored? Because you say you have to make your will, and then you have to register the will.
Well,
So if I don't register the will, and I come and I die, but I have my will, and Mary knows where the will is, but can the will still be honored?
yes, it can registration or lodging in the registry is really, I think, for safekeeping.
For safekeeping?
Yeah. Some people make their will and they hide it somewhere.
Yes.
They leave it with their attorney. They leave it with a trusted friend or family. But they don't always go and register. In the registry. Sometimes they may make one will register it, make subsequent wills, so when you're on an application for probate, it's always, you have to do a search first to see if there are any wills lodged in the registry.
And I'm
But
going
it still can be a valid will, or
valid will.
application for probate can be done Yes,
even though the
it's
will
not
is not registered.
in the registry.
And I am seeing my dear friend Listra here is asking a question, and I'll take the question from her. It's a question that we have, but let me read it from Listra. Listra, good evening, and thanks so very much for your question. And Listra is asking, do I need a lawyer, or can I write my own will and have it signed by 2 witnesses? Will that make it a legitimate document?
If it complies
With the
with the formalities under the law, in terms of the testator signing at the bottom of the will, the in writing, of course, the witnesses
And in
present.
pen and not pencil.
Right, yes. The
And I'm
witnesses.
assuming, sorry to butt in, but I'm assuming in pen and not pencil because someone could easily erase
yes,
and change
it's
your will.
temporary. Yes.
So, yeah, go ahead.
Yeah, so
Emily.
it has to comply with the formalities. The 2 witnesses must be present at the time.
At the same
At
time.
the same time. In Trinidad and Tobago, it must be at the same time. Yes. Yes, but other jurisdictions have different
laws to,
yeah.
So, you are saying that the testator can sign the will, but the 2 witnesses, they must be there present together at the same time to sign off to what is the desire of the testator.
Yes, the testator can sign his will before the witnesses. But when the witnesses come to attest, he has to acknowledge his signature. They must have an opportunity to see his signature.
Yes.
So he must show them, this is my signature, this is my will, this is my signature. Even though he doesn't sign it at the same time when they are present. But they have the opportunity to see it, and he showed them, and they say, this is my signature.
Okay. So when you say to show or to acknowledge, you mean like an ID card?
No, to show them the document.
And you're pointing that this is my signature.
Yeah.
So, okay. So the witnesses
they
does
must have
not have to
opportunity to see.
authenticate the testator's signature, meaning, okay, I signed my will and I'm waiting for Anne-Marie and Miss Lynch to come witness. So I don't have to sign in your presence, or I don't have to show any form of identification so that you can compare that the signature that I am seeing on the will is indeed my signature.
Well, it's not necessary under the...
It's not.
But acknowledging means that they have an opportunity to see. And
To
so
see.
when they're tested, okay, they say this is the signature that was shown to me by the testator as being his.
Yes.
So, but I don't know. Sometimes to avoid all unnecessary things, it's better, of course, if you sign it. But life doesn't always allow for, that to happen.
Yeah. I hope that answers your question, Listra. And so your will doesn't have to be registered, to be enforced, or to be honored, but it must follow the proper outline, very in simple terms, because we don't want to be on,
Simple
to
yet
confuse.
specific, identifying your assets.
So my piece of land situated at so and so, or I may have 5 vehicles. So vehicle P whatever blue is to be willed or
Specifics,
gifted to so and so. So the will must be very, very specific in terms of what is to be gifted to each person. So what is the cost attached to registering a will? Because sometimes you would hear that is very costly, and
No.
that is why sometimes some people may not want to go to.
It's minimal,
Is it
$3.
Ministry of Legal Affairs?
No, High Court.
High Court.
High Court, probate registry.
Probate registry. Can you
Registry.
repeat that for me, please?
Probate registry.
Probate registry.
The High Court of Justice.
Okay,
Or
Hall
the
of
Hall
Justice.
Hall of Justice.
Yes. So, and it is it's a minimal cost to register?
I think, if I recall, it was $3. I don't think
$3.
it's not exorbitant. It's not exorbitant at all.
Yeah.
I think they need to review the.
And you're saying,
fees.
because, and this is the question that we were coming to, if I do not have a financial ability to pay an attorney to make a will for me, can I make one for myself, and where do I have to register my will? So we would have answered that. And then in addition to that, the question I would like, and I'm throwing this out to Anne-Marie Mislynch, in terms of how long does it take for the registration process? And what, when you go in to register your will, what can you expect to go through in the registration process?
It is not, well, pre-COVID, I'm not sure how long, with COVID regulations, there was, people complain about, length of time things took to get done, and whether I needed an appointment. I'm not very sure, but it's a day process. It's not because the testator can carry in his will in a sealed envelope, of course. He can carry it himself, or he can appoint someone to carry it and register for him on his behalf. But that person must have some letter of authority from the testator,
Giving him the authority to register the will on their behalf.
On their behalf. The register, I think, carry the seal envelope. I think they would open it to verify the contents, and the testator to attest that this is his last will and signature, this is his signature on the document, and so forth. And the register with minute a file or minute it in the registry. And it would be the original would be lodged in the registry. So when, after his death, the original is always kept in the registry. A copy would be issued to the executor for application purposes when the time comes to apply for a grant.
A grant.
So the original is always kept.
And that's a grant of probate of
Grant
the will.
of probate, yes.
Okay. All right. Let me check and see if anyone has any questions out there. Okay. I remember in our discussion, Anne-Marie, when we were preparing, that I had asked a question, and I'm seeing one here.
One similar.
Similar. And you said, no, not according to the law. But I would ask the question, and this person is asking, can a video be done as a will?
No.
Or I was even alluding to as well, can a voice recording as well be done as a will and left there, and that be honored in the court of law as my last will and testimony?
Our law provides it to be in writing.
Yeah, not intentional.
Well,
In
we need to start changing some laws here.
In writing.
Because if let us say I'm on my dying bed, I didn't write a will, but I have a little life in me still, and I want to gift my assets, my property to my loved one. I want to ensure, and seeing technology how it is now, I can take up my phone and I can make a video, and that can be considered my last will and testament, but not in the laws
in
of Trinidad and
The
Tobago.
law has to change.
So I am appealing to the good Attorney General and the government to please change that law, so at least it can be included that you can either make a video or you can make a voice recording, leaving that as
Well, in
your
technology,
final
there's
will.
so many things that can go wrong in terms of video curriculum. Sometimes you see a video and you swear it's the individual, and
Yes.
that is
Yeah.
Yes.
A lot of times people have the ability to manipulate. With technology. So it have to be considered.
So even so let us say that the laws of Trinidad and Tobago has changed, and they are now saying that it is okay to accept a video. Is it that you must do, just hypothetically, you must do your video in the presence of your lawyer, who can say yes, that this is indeed or was indeed Anne-Marie's last will and testament?
I'm not sure how that would, how that.
I can, because of my experience with how we change laws, I want to believe if the law will have to be changed, and if whatever they're going to put in its place, or maybe I should say, the law might be amended to include that
as an alternative, as an option.
As an option.
Okay.
And then they would have to give really serious rules to have that done. So I guess what they would have to do is come out with some really stiff rules to avoid the negatives that could go
that can go with that. Okay.
Of course, they would look at other jurisdiction to see where it applies and how it is done.
Yes. I am going to take 2 questions from online, and it is always so nice to see when persons are, you're asking questions that we would have prepped for or we would have come up with. But this person is asking, can someone who receives property from a will be exempted from stamp duty on deed of said property? And I guess, let me see if I can...
Exemption for stamp duty relates to the value of the property.
Of the property.
So if the value of the property is not within the range, if I think was 800,000, I can't remember the specifics. If the value of the property exceeds the range where no tax is payable, then of course whether or not you get it under will or you bought it,
you're exempted.
No, you have to pay. Once the value falls within that range.
Yes, within that. Because one of my questions was is that if a person is gifted same property, and that property, the person owes taxes on that property. So I am now inheriting the property. Do I inherit the debt as well?
Of course.
Because I say that.
Remember, it's on the property, It's done up.
So you gift me something, and I now have to pay because the government will take it. So
I suppose probably the executor can pay debts out of
whatever money was left.
If it's
But
if it's
executor
sufficient.
has a rule that he pays all these things, like taxes, so he would have to deal with that.
Providing that there is monies to take care of that.
Well, if there's no money,
then I also inherit the debt. And if I want the property and I don't want the government to take the property, I have to ensure that I clear off all taxes owed against the property. All right.
Also, those beneficiaries could maybe come and help to pay those debts, don't you think? If they get cars and land and all of that.
It sometimes depends on how the testator crafts his will,
And I just want to, this is going so nicely. I don't want to only stick to what we have here, but I am seeing here, a listener is asking, it would be nice if I kind of seen the other person's names as well. Also, where can I obtain information on the proper requirements, and in brackets she has position of the signature to be able to create my own will. So what she's asking,
Okay.
yes.
That's under the Wills and Probate Act.
So she
Yes.
can go there,
Yeah, research the Wills and Probate Act. Yeah.
and you would see exactly.
Yeah, I think it's section 42 that deals with an execution of the will.
Okay. And Lystra, one of the things that we will be doing as well, either Anne-Marie or Ms. Lynch will be providing us with a simple example of a will.
Yes.
And we would also have that posted on Facebook and Instagram and the website. So anyone can visit and look at the whole structure of the will and where the signature is supposed to be as well. Let me see if I can get one more in before we jump back, because I'm seeing now it's now 6:42. This person is asking, is there a deadline or a cutoff point after someone dies for the family to locate and present a will? If so, how long? So, okay, the
What's the
person,
question again?
the person dies, we may not be able to, or you may not even know that the person left a will, and you may be cleaning out, and then in cleaning out, let's say 2 years pass, and you didn't know that the person left a will, and so you're cleaning out, and then after you're going through your study and you realize, but look, mommy left a will for me, or she left a will for the family. Is there a stipulated period of time that will can be honored, or now that I have the will, I can enforce it in terms of the wishes of the individual?
Well, having found the will, I can't recall the specific time, but I know it provides for a period of time in the Act. But notwithstanding, life has all different connotations. So many times people are not aware that a will exists.
Yes.
That's hence my previous advice, where sometimes you need to inform the person that, one, you're executor and I have a will.
And not everybody, if I dare say it.
Well, you don't want to, you have to know your family.
That is it. Because you may you may make a will, and then you tell the family members that you made your will, and then all of a sudden now, and sorry for being so blunt, but it is a reality of life.
Yeah.
They're doing all sorts of things to make sure you're dead quick, so that I can inherit the assets.
You kick the bucket.
Yes. So I have now started to ill-treat you and all these sorts of things to ensure that what you have left for me comes faster to me.
But when the application is being made, having found the will, the affidavit of the applicant would include reasons for the delay in applying, for the probate after 2 years or how many years. And it's a real situation. I have a friend who, the father died, and she is still in the process. He died in 2018, I think. I mean, notwithstanding COVID. She is now still trying to ascertain assets, where they are, if he had bank accounts. Sometimes, aged persons are so secretive.
Yes, yes.
Yeah, she knew he had a will, but, now is the time to find assets and to do an inventory and to, so the time, 2 years has already gone. And she's still now looking to start the process.
Okay, before we go to a commercial break, because I'm seeing it's now 6:45, but before we go to a commercial break, there's a question that I want to ask that is really, really burning. So let us see that an individual or individuals, they petition the court, the family court, to be separated, legally separated. From what I understand, even though you would have petitioned the court to be separated, it doesn't mean that you are divorced, you are still married.
They're still married, but judicially, you have a judicial separation.
A judicial
if that's what
separation.
that you're talking about. Okay.
Yes, yes.
Not divorce.
Not
okay.
divorce. So in understanding that, so I can't live together with this individual anymore. So I would have petitioned the court for legal separation. So in legal separation, I'm no longer married, but I am not divorced either. And I cannot marry anyone else. Yes?
Right.
In a situation like that, how can a will be handled in terms of I am not married, but I am not divorced? So, is the will, or if I make a will, and let us say that I am now living common law, how can that be handled? We'll go to a commercial break, and when we come back, we will answer that question, and then I guess we will just wrap up. So,
Time.
time. We are going to a commercial break, and we'll be right back. Good evening, and we are back live, and we are streaming from the Western United Credit Union headquarters, situated at number 40 Fitz Street, Woodbrook, Port of Spain, Trinidad and Tobago. And for those of you who may be now joining us, to my right, I have Ms. Anne-Marie Francis Giles, Director of the Board of Western United Credit Union and an attorney at law. To my left, I have Ms. Joyce Lynch, second substitute of Western United Credit Union Board of Directors, and she is also an attorney at law. So before we went off to the break, and ladies and gentlemen, before, just in case I forgot, and I think I did at the beginning, this is only part 1 of wills and trusts. So we will be having part 2, and from how the discussion is going, it may have to be very soon, because this is very, very important for persons to understand the importance of having a will and for doing it in the proper manner in terms of what is required by the law to ensure that it is honored. So before we went to a break, I asked the question, and maybe just to simplify, I petitioned the court for legal separation. I am no longer married, but I am not divorced. I cannot get married either. So I may have started a relationship with someone else, and this person may have been really good to me, and I decide that I am going to gift my assets, my properties to this individual. Seeing that, and I know this is a very ticklish question because and I would really love to hear your legal minds answer this, and if we can't answer it now, we can always come back and do so. But can this person, I am not married, I am not divorced, I am living with someone, and I gift my assets to this person. The person with whom I was married with initially, can this person now challenge this will?
That is a
Articulate
yeah,
one.
but the person is still a legal spouse. Even though they are separated, they can choose to. But on what grounds are they going to challenge it?
But maybe what we can do
Go ahead.
in part two, maybe I think we could answer that question.
Yeah.
In part two, I think we can take up the challenge and answer that question. Let me see if there are. I'm seeing great session, Lucian, and we thank you. Address the difference between a will and a trust, and how can you set up a trust for someone? That is, I did not pay particular attention to the trust part of it just yet because I know that we'll be having part two. So, Lucian, in part two, we will address the difference between a will. Of course, we will recap what is a will and what is a trust, and we will answer your question, how can you set up a trust for someone? We're going to need a next webinar to cover most of the issues. You're sure right about that. I think this is a topic that needs more time to discuss. We certainly will do that. Let me see if there is anything. There are many questions in the chat. Is there a time frame to determine a common law relationship? Also, what is life interest on a property? Okay, so I am guessing common law relationship.
You must have been, living with the man or woman for 5 or more years.
For 5 or more years. For them to
be,
have any claim to
and
a
to
will.
be the law to consider
consider
in a
you
cohabitant.
A cohabitant. So, Anne, can you kindly repeat that, please?
You must be, or you must have been living with the male or female in a cohabitational relationship for a period of 5 or more years.
Okay. I hope that answers your question. And I am seeing here last question that I'm going to take from the chat. This webinar too short. We need at least 2 hours. Certainly, I will take your recommendation into consideration. And last question from the chat. If in the event that there is no will, who takes charge of the assets and distribution of the belongings of the deceased? So there's no will.
Oh, well, that's what we call intestacy. The person dies intestate. So now the assets are really will be vested in the Administrator General for the state until someone applies for a grant of letters of administration. Right. And the law stipulates, who can apply: a spouse, or surviving spouse, a next of kin, the Administrator General, if the person dies intestate. Which goes back to what I said before. Making a will gives you control.
And that is what is important. So it goes right back to the top.
Yes. So you may have a where the law applies for a surviving spouse. You may have been separated from the person, whether judicial separation or just you go your way, I go mine.
Yes, yes.
Yes. But that person is still a legal spouse under the law.
Under the law. And they
Yes,
can challenge
they
the
can
will.
still apply. They're
Yes.
still under the law. They can apply for letters of administration.
And very quickly, Anne-Marie, when we say letters of administration, what is letters of administration? What do we mean by that?
Well, that's a legal court-issued document giving the applicant the right to administer the estate. So it's a grant. We have a grant of probate in a will, and in instance where it's intestacy or no will, the court gives you a grant of letters of administration. So you become the administrator of the
property,
of the estate of the deceased now.
And if no one challenges the letter of administration, does it mean that the person who applied for the letters of administration, they are now inherent of the
No,
property or the assets?
it's only invested in you in a legal capacity. You now have to treat with the assets and the estate and bequeath to beneficiaries under law.
Okay. Okay.
Right.
So it is not to say that you apply and you hold everything.
No, that's
still. That's what you would class.
No.
Yes.
Yes, no, because in instances like that, that's a crime you're committing.
You're committed.
And I have experience where I knew of a gentleman who was separated from his wife for years, and he died suddenly, and she showed up and took charge.
After all those years.
Yeah, she showed up and took charge, and the children were angry, but she took charge, and she was still the legal spouse.
The legal spouse.
Yeah, so the will gives you, as I said, gives you control.
Control of what your wishes are in terms of the distribution of your assets.
Yes. So in the event that you die intestate, the law stipulates how your estate is going to be divided.
Yeah, wow. Okay. So, ladies and gentlemen, it is now 6:58, and it means that we are almost to the end. And to think that we have only just begun. And this is why such an important topic must be discussed twice. So I have a lot of other questions to ask, and one of the questions that I have to ask is, what is a deed of gift? And is it a wise decision to make such a judgment before one dies? But that is just a little tickler, a little teaser for part 2 of the wills and trusts. So, fellow cooperators, I wish to thank all of you for your time. Thank you for joining. Please spread the word. This will be made available to you online on Facebook, on our website. You can visit our website maybe before the end of the week, and it will be posted on our website so that you can share it with your friends and your family. Please stay tuned for part 2 of Wills and Trusts. Thank you so much for your time, and as we continue to partner together to ensure that your life is more meaningful, we look forward to having you at our second webinar of Wills and Trust. Good evening and thank you.